Marconi Armory's out there, Fluffy Bunny Arsenal, and a bunch of other good people. Jacob's out there. We're going to be joined by Flying Rich today. Flying Rich, plane crash expert extraordinaire. We're going to be going over the new mock decision and the reason why we are doing this. Why we only have 7 people in there?
Are you on the news channel?
I'm on the news channel. It's really weird. Yeah, it must be. It's going to pop off here in a second.
Marconi.
But whatever.
DB Cooper, Bob.
The reason why we're doing it on here, like a live stream, is because a bunch of stuff is breaking and YouTube likes for us to mix it up a little bit. I guess you can say.
Okay. Johnny 3 Bar, what's up?
Apparently, no one got notified that we're live on the news channel.
Yeah, that's weird.
All right, I'm gonna go ahead and share everything out here, I guess, because I want to get. Dude, it's not showing.
Kurt 24 is Kurt 24. Oh, there he is. Hey. Oh, and I'm messaging the Gideon folk. Let's pimp the Gideon.
Yeah, do that while I get this out. We're gonna jump into it in a second, people.
Gideon Optics sponsoring the channel with their cool AF optics. I actually haven't opened the bag yet. I messaged them this morning. I'm like, hey, do you have tracking for the last order I placed?
All right.
And they're like, oh, here it is. I'm like, there's a picture of it leaning up against my garage door from Friday. Jordan Vinro, good morning, sir.
11 people. So let me go ahead. I'm going to share this out and try to get more people in here. But then we're just gonna do it. And so
we're gonna put the hammer to the floor.
Yeah. So let me go ahead and do this. I'm gonna just share it out on Twitter and everything. But today we're gonna be talking about a new ruling that came out in the mock decision. It came out shortly before midnight last night, and like I said, I'm doing this way because I got multiple stories going up, and I got something else going on pretty damn shortly here, so it should be interesting. So we're
just gonna have an all day long live stream.
No, that the other one I'm going to be listening in on the whatchamacallit, the New Mexico stuff.
Oh, jeez.
Okay, so let's go ahead and jump into it. Apparently, it's starting to go now. Okay, so late last night, a little bit before midnight, Judge Reed O'Connor, who is known as the Benitez of Texas, issued another ruling in the pistol brace. It's a huge win for it. And let me just do my breaking news. Breaking news! All right, let's go ahead and bring it up. Rich is going to read it. He is the play-by-play, and I am the color commentator on this.
Indeed. So, okay, let's see. Can we make that any bigger?
The preliminary injunction background. We all know what the background of the whole entire thing is. The new rule, blah, blah, blah. Then it goes into here. Actually, let's read a little bit of this. So go ahead, Rich.
Okay. In first major federal attempt to regulate firearms, Congress enacted National Firearms Act of 1934, which focused primarily on dangerous and concealable weapons used by organized crime. To that end, the Act identifies 8 specific categories of firearms that are subject to certain registration and use requirements and associated taxes. Relevant to this dispute is the category of short barreled rifle, SBR, a rifle having a barrel of less than 16 inches in length, or a weapon made from a
You don't have to
rifle.
everyone
Anyhow,
knows about that. So,
just me.
basically, what this is saying is just giving you a little bit of background, so on the NFA.
30 years later, Congress enacted the GCA, Gun Control Act of 1968, which expanded federal firearms regulation in an effort to address widespread traffic of firearms, their general availability to possession, those whose possession thereof was contrary to the public interest. Hudson versus the United States, statutory references
You
to
don't have to read any of
go.
that, just read around
Mm, where are we? I
the
don't see your mouse.
GCA.
Oh, the GCA amended the NFA in some respects, defined additional terms, and reinforced the NFA in others. Among other terms, the GCA defined handgun as a firearm which has a short stock and is designed to be held and fired by the use of a single hand, any combination of parts from which a firearm described in subparagraph A can be assembled. The GCI identified a rifle is identical to that of the NFA.
Okay, so basically, what's going on here is just um, setting up what this is. This is the ATF has the authority. Attorney General has the authority for that. So go ahead and read from since 2012.
Since 2012, the ATF has seen a proliferation of stabilizing brace devices, which were originally designed to assist people with disabilities or limited strength or mobility to safely and single handedly fire heavy pistols. With time, the devices began to include characteristics resembling shoulder stocks, and the ATF soon learned that manufacturers were widely marketing these braces to consumers as a mean of cheating the functional SBRs to avoid the NFA requirements.
All right, so basically, it's just going over why they made the rule. Blah blah blah.
You can shoulder it. You can shoulder it. You
Yeah.
can shoulder it.
Then let's talk about the worksheet 4999
Oh, jeez.
that never went into effect. But I wanted to touch on a couple different things here. And this is so let's just start with here.
While the NPRM had proposed a table worksheet 499999, like Iraq Veteran 8888, allotting points for specific criteria, the final rule did not implement the weighted point system. The final rule took effect immediately for newly made and transferred firearms, while individuals already in possession of subject firearms were given a 120-day registration period ending May
Yeah,
whatever
they come
came
into
into
compliance with the
compliance with
final
the
rule.
final rule. ATF began enforcing it. For those in previous lawful possession of subject firearms that declined to register them by May 31st, the ATF demanded that before the registration window closed, they must have otherwise removed the barrels from the firearms and attached a 16-inch or longer barrel in their place, permanently altered or disposed of their stabilizing braces so they could never be reattached to their firearms, divested themselves of the firearms by turning them into the ATF, or permanently destroying the firearms. Keep going.
Yeah, this is one of the things I wanted to touch on here. Let's go
But
down the
even but even despite laying out these alternative directives for firearms owners, the ATF shortly thereafter explained, it is still entirely plausible for none of these measures to suffice compliance. To illustrate, the final rule
which is like
specifies that
what we've been saying for like a long time.
a firearm owner can still be criminally charged under the NFA for constructively possessing an unregistered SBR if their pistol could be combined with any number of objects that the ATF believes are demonstrative of a firearm's designed for shoulder fire. The set of subjective criteria the ATF lists for potential constructive possession of an NFA rifle comprises open ended, broadly articulated standards that are left largely undefined or undeterminable. The ATF has a decades long history of pressing regulatory enforcement actions based on its own constructive possession theories in other NFA contexts where the mere ease of creation of a subject firearm has been sufficient to support criminal liability for firearm owners under the NFA.
What does that sound like?
I don't know. Could it be the auto keycard case, Matt Hoover?
Yes. So this judge is actually taking a shot at the whole constructive possession thing.
Yeah, yeah, big time. The ATF barred compliance registration anytime after May 31st, whereupon still in possession of a braced firearm that did not submit to registration was then deemed overnight to have become a felon in possession of an unregistered NFA rifle. So too, it has since no longer been the case that any of the alternative compliance measures enumerated by the ATF, barrel replacement, brace disposal or modification, firearm divestiture, or destruction will suffice for avoiding criminal prosecution under the NFA through the final rules interpretation if it of it.
No,
I'm sorry.
we're going to get into something really cool here.
Following the closing of its registration window, the ATF reported that its registration compliance rate is a mere 8% according to the higher end estimates.
So
The
that's
the
saying,
judge wrote this?
yes,
Woo!
8%. That is 8% at the highest.
Not including my 3D printed braces.
No.
Liability under the federal firearm laws regulations adopted pursuant thereto carries a serious criminal penalty. For example, violation of the GCA subjects a person
Okay.
to fine.
This is just saying what the penalties are. We all know what the penalties are. This
Your
is saying
fault.
that the FPC is the one that brought this case with maximum defense. And this just talks about what they did, their procedural history of the case, and which we all know what happened. Um, so here it is. I'm going to go down a little bit more. Upon this says upon determination what it will basically what a preliminary injunction is. So let's go here. So one thing they have to do to get a preliminary injunction is do substantial likelihood to succeed on the merits of the case. So go ahead and read this.
So plaintiffs were first required to demonstrate that they are substantially likely to succeed on the merits of the claims. Daniel Heath, all right,
No,
that's
you
just the,
just go down
sorry.
to following the Fifth Circuit.
Following the Fifth Circuit Court decision controlling law of this case, that the plaintiffs demonstrate a fortified, whatever, an actual success on the merits of their APA challenge to the final rule, holding that the final rule fails the logical outgrowth test and violates the APA, therefore must be set aside as unlawful. The court wholesale adopts that conclusion as its own as well. Yes.
Remember what I'm saying? What we were saying is like a bait and switch they pulled.
Mm-hmm,
This
mm-hmm.
is exactly
Yeah,
what
so they're like, hey, here's a worksheet, and this is how we'll do. And of course, the worksheet has the bonus prize of, they can spin and determine, even though you're less points than required to be unlawful, they could just determine it's unlawful anyhow.
Yeah, right here, this is showing irreparable harm. Irreparable harm is basically any harm that can be done that cannot be rectified via money. And since this is a criminal statute, there's irreparable harm right there. And this is saying that FPC members will sustain irreparable harm if this goes through. So, yeah. There
So
you go. There, I'm going to get down to here.
the ATF's own regulatory analysis concludes that the final rule has effectively reclassified 99% of all pistols with stabilizing braces to NFA rifles. Through seminal final rule adjudications, the ATF has already reclassified a whole host of specific weapons platforms and commercially available braced firearms to NFA rifles. Upon review of this record, in conjunction with plaintiffs' declarations, there is no doubt that the final rule will subject both FPC members to criminal liability for currently possessing each of their braced pistols. The moment the Fifth Circuit's injunction dissolves, Mock and Lewis will become felons because their braced pistols have become unregistered SBRs under the final rules reinterpretation of the NFA. Keep going.
Yep.
Furthermore, Mock and Lewis's possession of these specific braced pistol models and platforms, which are newly classified NFA rifles, has been revealed in precise detail to the government defendants in this litigation. Thus, the two FPC members are likely will be prosecutable to any point in time, absent the court's preliminary injunction against the government defendants' enforcement of the rule. The evidence suggests that without such relief, the FPC members are barred from carrying out their concrete plans to acquire additional braced pistols for home and self defense at this point in time, but for complying with the final rule, added NFA requirements, or facing criminal charges under the NFA through the final rule's enforcement. Neither FPC member wishes to comply with the final rule with respect to
Okay.
the braced pistols.
Yeah, you can stop there. Just saying that they don't want to comply.
Yeah.
And they find credible threat of potential criminal indictment. And there's non-recoverable compliance cost there as well. So basically, this saying that they've met everything to get a preliminary injunction. I'm going to go down here because I want you to read a couple different things. So they took a shot at the whole entire constructive possession thing. And I'll read from
Mhm.
here.
The situation becomes far more dire for the FPC members in the absence of the court's intervening protection when one considers the burden of the final rule threatens to impose on their fundamental right to keep and bear arms in self defense, where a plaintiff's alleged fundamental right is either threatened or, in fact, being impaired. The plaintiff is substantially threatened with irreparable injury. Such is the case because once an infringement has occurred, it cannot be undone by monetary relief. Thus, the plaintiffs need only properly make an alleged violation or deprivation of constitutional right to demonstrate the irreparable harm is being suffered or threatened.
What Judge O'Connor is saying is anytime that your constitutional rights are violated, that is irreparable harm. You don't have to prove anything else. All you need to
Amen,
do
brother.
is say, "Hey, it's violated." All right, now go from here.
In this litigation, plaintiffs allege that the government defendants' promulgation of the final rule violates their constitutional rights provided under Second Amendment. Separate from the merits of this claim, the court finds that the government defendants' implementation and enforcement of the final rule substantially threatens to inflict irreparable constitutional harm upon the FPC members. Absent injunctive relief, the final rule will impair and threaten to deprive them of their fundamental right to keep and bear commonly used arms as a mean of achieving inherently lawful ends of self defense.
All right, now go down here. This is, remember, the ATF try to say that they're not in common use, they're dangerous and unusual. We're going to get to that
Right.
right now.
Weapon in common use. The Second Amendment prohibits the government from infringing upon an individual's right to keep and bear arms for self defense.
And
And
Heller is cited in there. Heller is a friend. Dick Heller is a friend of the channel.
And this protects the individual's possession and use of weapons that are in common use at the present time. Quoting Heller,
Mhm.
conversely, protection is not extended to the possession or use of dangerous and unusual weapons. A
Ba-
weapon is
that- Basically, the government have been trying to argue that braced pistols are dangerous and unusual.
A weapon is in common use rather than dangerous and unusual if it is commonly possessed by law-abiding citizens for lawful purposes today. Let's see. Heller and
Let's just go
holding
down
that
to the
Second Amendment.
relevant. The relevant.
The relevant inquiry under this standard is that the current total number of a particular weapon that is in lawful possession, ownership, and in circulation through the United States.
And there's millions of them.
As per se, matter semi-automatic pistols are commonly used weapons for lawful self-defense purposes. And
And that actually quotes Rahimi, which is a Second Amendment case that is going up there.
the court finds that braced pistols, subject to enforcement of the final rule, are in common use today. For starters, it is undisputed that pistols such as those in the FPC members' possession on their own and without stabilizing braces are already deemed to be among the weapons most commonly used today for lawful self-defense purposes. ATF agrees that the weapons here are lawfully bearable pistols absent a rearward attachment. These pistols are therefore lawful. A stabilizing brace does not somehow alter the status and effectively strip these pistols of their Second Amendment protection.
The
The
judge is
government's
just smacking them down here.
Yeah, this is very serious smackdown. The defense assertion to the contrary that the pistols do become dangerous and unusual as soon as a stabilizing brace are attached to them does not survive on its own administrative record. The ATF's regulatory analysis concludes that there are between 3 and 7 million, with 50 percentile estimate of 5 million based braced pistols under ownership of law-abiding individuals for lawful purposes throughout the United States. In the final rule publication as well, the ATF did not dispute noteworthy public comments pointing out that millions of braces are in use and that braced pistols are commonly used by millions of law-abiding Americans for various reasons. On the other hand, the ATF conceded that since 2012, the variety of available stabilizing braces or similar brace devices and pistols equipped with braces has grown significantly. Supreme Court guidance and sister circuit precedent postulate that this record is depositive of the matter. Let's see. Finding that stun guns are in common use based on hundreds of thousands of tasers and stun guns have been sold to private citizens who it appears lawfully possess them in 45 states. Let's see, finding automatic semi rifles, own AR style semi automatic rifles in Heller versus DC. Finding semi automatic rifles are in common use based on approximately 1.6 million AR
And
15s
that's from
have been
2008. There's a
manufactured
lot more now.
since 1986. Heck,
Mm.
that's what they do a week, and never mind. Accordingly, the court finds that braced pistols regulated under the final rule are commonly used by law abiding citizens for lawful purposes. The FPC members' possession and use of braced pistols is therefore within the ambit of the Second Amendment protection. See Bruin.
Yeah, and way this is they're saying that it's protected by the Second Amendment. Um, so
Big deal.
therefore, you they can't do it.
Right, and that's a substantive smackdown. That's not
Yep.
just a couple of weaselly words. The Supreme Court has already established that the text and history of the Second Amendment's operative clause, the right of the people to keep and bear arms, U.S. Constitution, Second Amendment, protected individuals' right to possess, carry, operate a commonly used handgun in home and in public for the lawful purpose of immediate self-defense. See Heller. Holding the text and history cover home possession of commonly used handguns for ready use in armed self-defense.
Okay.
Bruin,
This
well,
is saying this is basically saying that there's no text, history, and tradition to give it that
that brace pistol should be illegal.
yeah.
The more
The successful performance of
Okay.
armed
The
weapons.
successful performance of armed self defense entails not only deterring or neutralizing life threatening perpetrators, but also preserving innocent life by preventing bodily injury to others as much as possible. Users directly advance these fundamental ends of self defense when they modify lawfully bearable pistols with rearward attachment, whether as a brace or a stock. The increased control and precision to pistol fire materially lowers the probability and potentially lethal misfire and collateral damage, as well as being outmatched by or falling a victim to dangerous assailants. Such safety
Safety
improvement
improving. Safety
that
improving. I just want to put it.
that's kind of brilliant right there.
There you go. Right.
So safety improving modifications are especially critical for permitting disabled and weaker persons to fire pistols more easily and more safely and more controllably to accomplish a more proficient and exacting self-defense. Wow,
Yeah.
that
So
that's a
basically,
big
you're
deal.
saying this is safety improving, and it's a good.
Ooh.
Okay, this is good right here too.
The history, interwoven with the right of the people to keep and bear arms, U.S. Constitution Amendment 2, indicates that the Second Amendment's text has long incorporated the right of personal gunsmithing, the right of private individuals to modify or require modifications to lawfully bearable firearms, such as to increase the accuracy and safety for more effective exercise of self defense. For example, in order to sustain themselves against a large and well supplied British military throughout the Revolutionary War, the Americans relied on gunsmiths, individuals with know how from working on their own arms, and Americans who were willing to learn the art of arms manufacturing. The American tradition of self made arms, let's see,
Yeah, go right down
analogous
to right down to here.
Analogous to the role that stabilizing braces play for contemporary pistol owners, founding era gunsmithing involved in modifying lawfully bearable pistols with extended grips and rearward stocks to facilitate greater stability and control and accuracy in single handed firing self defense fire. The court is persuaded upon this record that the Second Amendment's text and history presumptively guarantees plaintiffs Mock and Lewis the right to modify lawfully bearable pistol arms with rearward stabilizing braces for the purpose of improving the performance attributes necessary to successful armed self defense. And then it cites Bruin.
You know what? This is kind of this kind of reminds me of something. He looks like he's taking a shot at something. What is he taking a shot at, Rich?
Well, framing receivers.
No, he's taking a shot at the NFA.
Well, yeah, that too, for sure. Because now he's at, I've never seen this before, where he says accuracy, safety. It's like, dang, that's substantial.
Yeah, so now he's just saying that this doesn't necessarily mean that the ATF can't win, but they're not going to win, and
Wow.
they're trying to keep the status quo. All right, now get right here to this one.
Moreover, the final rule itself flatly violates the APA and must be set aside as unlawful.
Okay,
No,
basically the APA. We're gonna try to get through this guy. I gotta get on something else. It's basically saying that it's violating the Administrative Procedures Act because the ATF pulled a bait and switch.
wow.
And this is again when they talk about if once a fundamental right is infringed, cannot be undone.
Right. Unbelievable.
Yeah, so this is a very, very good ruling.
Yeah, this is a baller ruling on the level of Bruin, because this judge is taking no prisoners and he's expanding, like, hey, safety, security.
Yeah, that's why this is not clickbait. It expands everything. So start far from mere speculation.
Far from mere speculation, the court has little trouble finding that there are likely hundreds of thousands of FPC member firearm owners similarly situated to Mock and Lewis based on evaluation of the whole record of the ATF's promulgation of the final rule.
Basically saying that they know that there's hundreds of, I mean, millions of people with braces.
As
So
the court, oh,
so you can stop reading from here. We'll pick it up a little bit later. But yeah, so this is saying this is a very, 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 very strong ruling. It also says maximum defense, that they make braces so they can go out of business. And if they go out of business, they can't be made whole by, whatever.
So
That's
this
my
this
money.
is a 38-page ruling saying and giving very firm cases and backing up sightings
Yeah.
and expanding.
And the balance
Uh,
of equities fall. Just trying to get to this really fast. The
mhm.
balance of equities fall with people with braces. So that is good. Um, so this is the scope. Basically, FPC members are still a-okay, but this expanded on everything. So let's just read from here.
The court holds that each plaintiff has demonstrated entitlement to preliminary injunctive relief against the government's defendants' enforcement of the final rule of the
Okay,
United States
so they
Court of
win this,
Appeals.
and this is what the ATF have enjoined from.
Okay, so from implementing and or enforcing the firearms policy coalition and that its members and the provisions, basically you're an FPC member, you can get a brace, have a brace, keep a
Yeah,
brace.
or if you buy it or from Maximum Defense
And
or
yeah,
and
same with Maximum
any
Defense.
downstream customers. So if you're not a member of FPC GOA or SAF and you have a Maximum Defense brace, you're still a-okay.
Wow. So and again, if I want to resell that. So if I'm Joe Blow, not
Yeah,
FPC
yeah, you can
member,
resell it. I mean, that's still that brace is grandfathered, basically. I guess
yeah.
not the right words, but yeah, we just wanted to bring you this and everything. Um, FBC time. It doesn't really go into time period, so like a lot of people think that it doesn't really matter. You can like join today, but I'm not going to give you any legal advice on that because it's still not 100% clear. But it looks like it doesn't matter when you join. All right. You can follow Flying Rich at Flying Rich Firearm and Flying Rich on YouTube, flyingrich.com. You can follow me on John Crump Live and John Crump News. And with that, we are out of here. Thank you so much. I got to jump on something else and expect more video for today. Thank you.